The so-called Defensive Marriage Act it will be ruled on very shortly here. We expect possibly Monday, possibly Thursday of next week. The court's session finishes up at the end of June. So we're expecting a ruling really any day. And the impact of that ruling could be pretty important for same-sex couples and their families in Minnesota. There are 1,138 federal laws that dictate the way that the federal government treats married couples in the country. And with Minnesota's new marriage law and with the success of U.S. versus Windsor, which is the DOMA case, we would be able to trigger those 1,138 rights and benefits from the federal level into Minnesota for same-sex couples who are legally married in Minnesota.
So what we did here in Minnesota when we passed our marriage equality law, we took care of all the things that were on the state level. And that a lot of those, I remember I went through that whole list, 515, and, some of them are really obscure, like fishing licenses.
Yes.
And some of them are real basic, human rights, such as, health care. And a lot of those have to do with state employees. Businesses have always been free to kind of do whatever they want in Minnesota, but the state was held to whatever, the law was. Now what you're saying is this going to mainly impact federal employees in Minnesota? Is it going to have an impact that goes beyond federal employees in Minnesota?
Sure. There's a few different things that you can look at in those 1,138 federal laws. Some of the things that it would impact would be for federal employees, so health insurance for federal employees, for example. But some things are not related to federal employees. For example, immigration laws related to binational same-sex couples, where you have a couple who is legally married in a state and is not able to have the spouse who does not have a green card in the United States able to live here. The success of the Windsor case would actually trigger the ability then for a spouse who is married to their partner in a state with marriage equality to be able to sponsor their spouse to move to the United States, just like opposite-sex couples who are married are able to do. So that's another piece that's quite important. One thing that we're looking at quite carefully is the impact for taxation with the success for the Windsor case. Married same-sex couples in Minnesota would be able to file the same as married couples, both for their state return as well as for their federal return. And so you can see a lot of impact there. In fact, the case of the Windsor case actually stems from a situation where a married lesbian couple who is legally married in New York had the unfortunate experience of one of the spouses dying, and they were levied with a very expensive tax bill for the estate tax from their federal estate tax. And Edie Windsor, who was the plaintiff in the case, was given a $360,000 tax bill from the federal government. This would have been a tax bill of zero for an opposite-sex married couple because the estate tax would not apply. But for a same-sex married couple, because the federal government does not recognize that state's jurisdiction over marriage, that tax did apply for them. And so you see a number of different scenarios where couples in Minnesota will receive quite a lot of assistance and protection if the DOMA case, if Section 3 of DOMA does fall.
And I want to go back to that tax thing because, again, opponents of same-sex marriage always said, well, you can basically, through legal means, take care of most of the things that and get most of the rights that a regular, opposite-sex couple would have. But when you start talking about that tax thing, I mean, a $360,000 tax bill, that's not a small difference. That's a big difference. I mean, all human equal rights things aside, just for the moment, That's a difference I think anybody can see. It's a huge thing, and it impacts people, to a great degree. And I can't imagine why anybody could look at that and say, well, that's equal.
Yes, we actually look to see, because of course we've been hearing this for years, that same-sex couples are able to basically contract for the same rights and benefits that married couples are able to automatically trigger. And it's actually not true. It looks to us like there are about 46% or so of the rights and benefits and obligations that marriage affords automatically on the state level that you could really impact through some kind of legal contract. The rest of the rights and benefits and obligations that come along automatically with marriage, there's no way to impact those through working with a lawyer, through a legal contract. These are things that are strictly related to legal marriage that you really cannot impact in any other way. And in addition to that, lots of couples don't have the financial means to be able to hire the kind of lawyer that you would need to draw up these kind of contracts that would actually work. And so, of course, we're delighted that that type of thing is not necessary in Minnesota as of August 1st, and that same-sex couples will be able to marry and automatically trigger those same rights and benefits and protections for their families.
I want to talk about the other case that the Supreme Court has. We have a couple of minutes just left, but it's Proposition 8 is what it's called, and it's basically the California marriage case. It's basically same-sex marriage in California. And without going into all the background, it's basically deciding whether or not there can be same-sex marriage in California. There was a proposition that said that, maybe I'm getting it confused here, but that I think Proposition 8 said that there could not be same-sex marriage. Is that the way it was in California?
Yeah, what happened in California was that marriage equality became the law of the land, and 4 months later, Proposition 8, which banned marriage, went into effect. And so there was a window of time in which 18,000 couples in Minnesota in California were legally married, and then the ban came into place, and that stopped. And so what the Prop 8 case, or the Hollingsworth versus Perry case, looked at was whether it was constitutional to do that, whether it was constitutional to offer a right such as marriage and then take it away. And when the case has progressed, the last ruling on that was in the Ninth Circuit, and it was found that it was not constitutional to offer a right such as marriage and then take it away. And then that case was appealed to the Supreme Court, and as we talked about before, we're waiting for the response on that from the Supreme Court next week.
And so we got just a minute here. This could actually go either way, but it could be a very narrow ruling, which may not have a lot of impact, or could be something that just impacts California, or it could be something that impacts the entire country, correct?
That's right. There's a number of different directions that they could go, and it could be very narrow so that the families in California's marriages would then be seen as legal and marriage would start up again quickly. It could be a broader ruling that impacted a larger swath of the country, perhaps even the entire country. There's really quite a range of opinions that they could come up with, and we're just waiting to see what will happen.